In this lecture, we'll discuss the 4 different ways that cases come to the Supreme Court. Actually, of these 4 ways, one of them is far more common than the others. And so we'll have a full lecture devoted to the most common way, and this one will focus on the 3 least common. And the first way cases can come to the Supreme Court is through original jurisdiction. The Supreme Court is kind of a unique court in that it has both original and appellate jurisdiction. However, original jurisdiction is pretty rare, and in its most recently completed full term, the October 2018 term, it didn't hear any cases under its original jurisdiction, but it is interesting and we'll talk about it. The second way cases come to the Supreme Court is through mandatory jurisdiction. These are cases that the court has no choice but to hear. It must hear them. These are also relatively rare. In the October 2018 term, the court only heard 2 of these cases, comprising only 3% of its docket. The third way cases can come to the court is through certification, which we'll discuss. That's also very rare. No cases in the October 2018 term. And then finally, that leaves the common way. The most common way for cases to come to the Supreme Court is through a writ of certiorari, which made up 97% of the court's docket in October 2018 in that term. So in this lecture, we'll focus on the first 3. So let's talk about original jurisdiction. And again, this is kind of interesting. The court's original jurisdiction is spelled out in the Constitution. You may recall from Marbury v. Madison, it said the court has original jurisdiction in cases involving ambassadors and other public ministers, as well as cases in which a state shall be a party. And of course, in Marbury v. Madison, the court decided that Congress couldn't add to the court's original jurisdiction, but apparently Congress can subtract from the court's original jurisdiction, because today there's only one kind of case that the court ever hears under its original jurisdiction, and those are cases in which one state sues another state. Those are pretty rare, and that's it. Those are the only kinds of cases the court will hear under its original jurisdiction, and even then, it's discretionary, not mandatory. The court does not have to hear these kinds of cases if it chooses not to. My favorite of these kinds of cases is New Jersey versus New York, decided by the court under original jurisdiction in 1998. This is Ellis Island, and the case involved the question of who owns Ellis Island. And if you're like most people, you think that New York owns Ellis Island. This is the place where immigrants came and landed as they were coming over from Europe, where they were processed before moving on to the rest of the country, and most people historically associate it with New York. But New Jersey sued and said that they owned most of the island, because although there was an original island, and there still is the original part of the island, much of the island is reclaimed. The island is larger today than it was in the past because it has been filled in, and New Jersey claimed that it owned the new land and that New York only owned the original part of the island. In this case, the court did decide it, and they did decide in favor of New Jersey. So if you ever visit Ellis Island, you can actually visit 2 states just by taking a few steps. Another interesting such case is Mississippi versus Arkansas. The state border between these 2 states was originally drawn at one point with reference to an island in the middle of the Mississippi River. But over the course of time, the position of that island shifted, and the question in this case, which the court did answer, was whether the border between the 2 states had shifted along with the island. One example of a case that the court decided not to hear was when Nebraska and Oklahoma sued Colorado in 2014 following Colorado's legalization of marijuana. They were afraid that people would be bringing it back across the border into their states, and they sued to have the Supreme Court stop Colorado from legalizing it. The court turned that case down. Original jurisdiction cases have sort of an interesting procedure as well, because if you'll recall, original jurisdiction courts are trial courts, and so in these cases, the court actually is supposed to find the facts, and it's supposed to act as a trial court. But trials are time-consuming. You've got to have witnesses, and you've got to sift through a lot of evidence. And of course, the Supreme Court, doesn't have the time for all of that. And so what it does is it hires somebody who's known as a special master. This special master is usually a retired lower court judge, and this is an individual who conducts the trial. Usually it's often a district court judge who's got experience conducting trials, and they conduct the trial. They have the witnesses called, and the attorneys make their arguments, and so on and so forth. And then the special master makes a ruling which serves as a recommendation to the Supreme Court. At that point, the court hears oral argument over the recommendation or about the recommendation, and then rules on the case as it usually would. So in reality, original jurisdiction cases aren't that much different for the Supreme Court from the other cases that it hears, because it hands off most of the work to this special master. The second way cases come to the Supreme Court is through mandatory jurisdiction. These are the cases the court has to hear. And once upon a time, the court had to hear all of the cases that came before it. That's because not very many cases came before it. In fact, one year, the Supreme Court's term was canceled because there were no cases. But, of course, the country grew and more cases came to the court, and so in 1925, Congress for the first time made some cases discretionary. They continued to pass more and more laws, making more and more cases discretionary until 1988, when Congress almost completely ended the court's mandatory jurisdiction. There are a couple laws that the court still has to review appeals from, but for the most part, mandatory jurisdiction has been ended, as we saw, making up 3% of the court's docket in the 2018 term. The final way a case comes to the Supreme Court is through certification. Certification occurs when a court has a case in front of it, but it feels like it cannot rule on that case because there's a legal issue or a legal principle that has not yet been decided by another court, and that the first court doesn't have the authority to make the ruling. So when that happens, Court A, the court that feels like it needs the information, can certify the question to Court B. And so what Court A is asking for is it wants Court B to issue a legal ruling which will then help Court A make its decision. Court B can accept or decline this invitation, and certainly that's the case with the Supreme Court. If a case is certified to the Supreme Court, they can decline that case. But one example of certification, although not involving the U.S. Supreme Court, occurred in Proposition 8, when the U.S. Court of Appeals needed to know whether the litigants in Proposition 8 had standing under California law. The Federal Court of Appeals could not answer that question because it was an issue of state law, and being a federal court, it can't interpret state law, and therefore it certified the question to the California Supreme Court, asking for a ruling. The California Supreme Court accepted that invitation, and it did issue a ruling in that case saying that the litigants did have standing. With regard to the U.S. Supreme Court, there's only one, the lower court that can appeal to it is the U.S. Court of Appeals. Any one of the 13 U.S. Court of Appeals can certify cases to the Supreme Court, but nobody else can. And again, these are very, very rare. The Supreme Court has only decided a couple of these cases over the last 50 years. This is the rarest of all the ways that cases come to the Supreme Court. That then leaves the Writ of Certiorari. The Writ of Certiorari, again, the most common way of getting to the Supreme Court, but it is not common at all. Every year, there are approximately 10,000 cases appealed to the Supreme Court, and yet, in the 2018 term, the court granted review in only 70 of those cases. That's a rate of less than 1%. We're going to talk about this one in our next lecture to try to figure out how does the Supreme Court go about choosing those lucky 70 every year.